Hello, everybody, and welcome to Voice for Men India. In a significant and long impending verdict that was pronounced this morning, the Constitution Bench of the Supreme Court, comprising of Justice S.K. Kaul, Sanjeev Khanna, A.S. Oka, Vikram Nath, and J.K. Maheshwari, have held that it can invoke its special powers under Article 142 of the Constitution of India to grant divorce on the ground of irretrievable breakdown of marriage, which is not yet recognized as a ground for divorce in India. To begin with, our divorce laws are fault-based, and either party seeking divorce to end the matrimonial bond must prove fault on grounds of either mental, physical cruelty, adultery, desertion, and others. However, in the practical current scenario, it is almost impossible to prove the nature of such allegations against the other spouse, particularly when the same would have occurred between the two parties in the confines of their matrimonial home. The other part of this judgment also held that the mandatory waiting period for 6 months for divorce by mutual consent can be dispensed with, subject to the requirements and conditions laid down in the previous judgments. First, let us understand what was this issue and why did the Supreme Court give its judgment today. The original issue that was referred to the Constitutional Bench was whether the mandatory waiting period for divorce by mutual consent as prescribed under Section 13B of the Hindu Marriage Act could be waived off. Simultaneously, during the hearing of this particular case, the Constitutional Bench also decided to consider the issue whether marriages could be dissolved on ground of irretrievable breakdown between the parties. What is irretrievable breakdown of marriage? This is a situation where parties have not been cohabiting together for long, fighting prolonged battles only perhaps to satisfy their ego, where the bond of matrimony is completely dead, yet one of the parties refuses to consent for divorce. One would ask, what are the factors that would be considered to hold that a marriage has been irretrievably broken down? While the Supreme Court has actually refrained from laying down concrete factors which should be considered to decide whether the marriage has been broken down or not, the judgment certainly specified certain broad factors which could be illustrative. The factors laid down by the Supreme Court in such scenarios would be the period of time the parties had cohabited after marriage, which is particularly the duration in marriage, when the parties had cohabited last, when did the separation actually happen, the nature of allegations made by the parties against each other and the family members, and also the orders passed in the legal proceedings from time to time and the cumulative impact on the personal relationship. Also, how many attempts were made to settle the disputes by the intervention of the court through mediation, and when was the last attempt made? Also, the period of separation should sufficiently be long, and anything about 6 years or more could be a relevant factor. Now, let's come to the question that has been running in the minds of many people watching us today, which is the question on child custody and alimony. The court has taken a broad view, keeping in mind the question of custody and the welfare of minor children, as well as the provision for fair and adequate alimony to the wife. The court has considered that while if it chooses to grant divorce on the grounds of irretrievable breakdown in marriage, it will have to evaluate the economic and social status of both the parties, including their education qualifications. It will also evaluate whether the parties have any children, their age, their education qualification, and whether the spouse and children are dependent, and in the event, how and in what manner the party seeking divorce intends to take care and provide for the spouse and their children. In my opinion, what the Supreme Court has done today through its verdict is they've tried to neutralize and end the trauma of all such dead marriages, where women usually misuse laws to settle scores. If we analyze the current scenario today, most men who are fighting such battles are left struggling with lawyers, multiple cases, no divorce, yet paying maintenance to their wives without any fault being proven. Alimony factor is surely debatable, but it does allow a window to the man to pay one-time lump sum amount to end his misery and perhaps move on with his life afresh. In my opinion, today's judgment is progressive in two aspects. It will legalize divorce for practically dead marriages and also declog our judicial system, where either parties are only coming to court for sadistic pleasure. Today's judgment will help courts to speed up justice delivery to, in fact, genuine victims, instead of pampering estranged spouses, particularly the wives, in the absence of this very long needed guideline.